Good morning and welcome to today's webinar, Mishandling Handbooks, Employers' Biggest Mistakes in Drafting Employment Handbooks. I'm Joel O'Malley. I'm an associate here at Dorsey and Whitney, and joining me today during the webinar is Jessie Mischke, another associate in our group in Minneapolis. As those of you who have worked with Dorsey before know, we've got employment attorneys spread throughout the country from California to New York, and so a lot of the issues that we will be discussing today regarding handbooks involve state-specific issues that you may want to consider if you have a multi-state operation. And so one thing to consider as we go through this is how Dorsey attorneys spread throughout the country might be able to assist you in drafting or revising your handbooks. Today we're going to focus on not just a random list of mistakes that employers have in their employment handbooks, but really look at what is the goal, what is the point of an employment handbook, and looking at what those goals are, what are the mistakes that employers then have in their handbooks that do not allow them to achieve those goals that you want to have by having a handbook. And when you forget to keep eye on those goals, that's when the mistakes happen. We're going to try to focus on these top 10 goals listed on the slide in front of you now: setting expectations, communicating policies, emphasizing the at-will relationship, avoiding wage and hour disputes, protecting company information, managing social media, maintaining your dress code, leave issues, harassment complaints, and then covering your bases. Hopefully we'll get through all of those as we work through the next hour. So with that, let me turn it over to Jessie to handle our first goal.
Good morning, everybody. As you can see, goal number one seems pretty straightforward, and it is to an extent. But that is to really set baseline expectations for an employee. And I think it's difficult when you're digging into each provision and going through revisions and the drafting process. It's easy to forget what the primary purpose of a handbook is, and that is to really inform your employees what's going to be expected of them, how they can raise issues with the organization, whether it's questions they have or complaints or concerns regarding misconduct that they have. So that's the purpose of the handbook. In order to really satisfy that goal, you need to be keeping a few things in mind, one of which is make sure that you're tailoring your handbook to your business. If you don't have company-owned vehicles, don't have a company car policy in the handbook because it's not applicable. In the same vein, be careful about form policies that you find online or that might be in HR resources, because those certainly won't be tailored to your business and also may not be compliant with the state and local laws in your jurisdiction. So that's something to really key in on as you're moving through your provisions, is make sure it speaks to your business, and then make sure that your provisions, when you're reading them back to back, are consistent and provide employees with the necessary information that they need. Second point is, in that regard, the complications often arise in the use of details. There are going to be provisions where you're going to want more details and a few provisions that you're going to want to beware of use of details. And we're going to touch on that point as we walk through some of our more substantive goals.
Jess, I think you make a really good point about pulling kind of cookie-cutter handbooks off the web. I know that I've dealt with several clients who've used maybe some human resources websites that allow you to click a button or not click a button here, and after you go through a bunch of buttons, it'll spit out a handbook for you. I've looked at those handbooks, and oftentimes you're right. They end up including policies that you don't actually need, or the policies that they do include are so broadly worded that they end up possibly causing more harm than good. So when you use those types of tools, it's probably still a good idea to run that type of handbook by your employment attorney. Moving on to the second goal, communicating policies. Really, the employee handbook is your primary vehicle as a human resources organization to communicate what the employer's policies are to your employees, giving them the ability to determine what those policies are on their own without constantly coming to you with questions. And in order to do that, you want to make sure to avoid a couple things. One, You want to avoid speaking in too much legalese. So that's an issue where maybe you want to get your handbook reviewed by the employment attorney, but the employment attorney should do a good job of not putting handbook language in too many legal terms. You want your average normal employee to be able to read the handbook, figure out what the policies are, know when they can answer the question themselves or whether they have to come to someone to HR to get a question answered. Another thing in communicating policies is you don't want to hem yourself in to take a position later on that you don't necessarily want to. So as attorneys, we are always thinking of the worst case scenario or what could happen if something that we haven't thought about now happens in the future. And in connection with that, we try to avoid saying that the employer will take certain actions if the employee does something, or that employees must do something if something else happens. So for example, if you have a work rule that requires an employee to do something, you want to avoid saying, if you violate this work rule, you will be discharged. You never know when there's going to be an exception that's going to need to be made for that type of policy. You don't want to cause yourself to have to make a decision that you don't actually want to make when the time comes. Another issue that Jessie mentioned a little bit is the amount of detail in the handbook. And this specifically relates to employment benefits, your health plan, your dental plan, insurance, those type of things. For those benefits, if you provide them as an employer, you're going to have other guidebooks, other things that you hand out to employees or make accessible to them via your intranet that describe those policies in a lot of detail. And those are the plans that are really the plan for purposes of ERISA or other insurance rules. You don't want to put too much of those details in your handbook, because then your handbook is going to become sort of an addendum to the official plan, and that's something you want to avoid. You want one place where employees can go to get the details of the benefits that have been offered to them. Now, it's perfectly fine in your handbook to discuss generally what benefits are being offered, describe them by name, and in general, perhaps the types of employees that are eligible for those benefits, but try to avoid getting into too much detail about the nitty-gritty of what those benefits are.
Goal number 3 is to create and then maintain at-will relationships. In at-will employment, which means that both the employer and employee have the right to end the employment relationship for any reason not prohibited by law at any time, is the general default position under the United States common law. There is an exception, as we flag for you on this slide, and that is the state of Montana, which has adopted a statute entitled the Wrongful Discharge from Employment Act, which actually establishes a probationary period for employees and also includes some other protections. So if you have employees in the state of Montana or are thinking of expanding your business to that state, that's something you'll want to keep in mind. And as Joel mentioned earlier, we do have folks in the Dorsey Labor and Employment Group who are licensed to practice in Montana and who can walk you through sort of those intricacies. So if at-will employment is the default, why do we care in the context of a handbook? We care because many courts, including some in Minnesota, have held that an employee handbook can give rise to contract claims based on the language that's used in the handbook. The seminal case in the state of Minnesota on that point is the Pine River State Bank case. And in that case, a former employee brought a suit claiming that his discharge was wrongful because it violated, he claimed, provisions in the handbook regarding basically progressive discipline and how the employer was going to walk through disciplinary processes, and also, in his mind, violated some job security language that the employer had in that handbook. So, in order to avoid contract-based claims, a few things you're going to want to do is make sure you're including at-will statements in the handbook. We typically recommend that employers include an at-will statement right up front in either the foreword or the introductory section, indicating to employees that employment at the company is at will and basically walking them through what that means. You're also going to want to keep in mind that that at-will statement may need to be reiterated throughout the handbook if you have provisions that deal with probationary periods or job security, any sort of provision that might make it seem to employees that job security or benefits are tied to duration of employment. So if and when you do decide you want to include those types of provisions, reiterate that nothing in this provision alters the at-will nature of employment at the company to make sure that you're securing yourself to the best extent possible against those contract claims that employees might try to bring if and when issues arise down the line. Related to that is failure to include disclaimers, and the inclusion of disclaimers has been something that at least some courts in Minnesota have said is sufficient to cut against these contract claims, and that is clarifying to employees, likely again at the beginning of the handbook in an introductory section, that nothing in this handbook shall be construed or implied as creating a contract of employment. So providing employees upfront that information that the handbook is meant to be a guide, it's meant for their benefit, but in no way creates a contract is important to have in the handbook. Next thing we typically recommend in this sort of contract at will context is to make sure that you're including an acknowledgement form at the back of the handbook. We often suggest that employers flag for employees that an acknowledgement form is at the end of the handbook, will need to be signed and returned to supervisors after the employees have read and understand the contents of the handbook up front, again in the introductory section. And what those acknowledgement forms allow companies to do is to point to the fact that, hey, we advised employees to take a look at this handbook closely. We wanted them to read it, to understand it, and they signed a form and returned it saying they did so. So that's something that employers are going to want to have in the event things continue and arise in the future. Last point on this topic is to make sure to reserve your right to modify or change your handbook at any time. There are often changes in the law that will require changes to handbooks, and we'll talk about that throughout the presentation, but there are also likely going to be times where you want to revise certain policies based on your own experience. So making sure that employees know that the company has reserved that right is important. And one last note on the at-will issue is that in drafting some of that language throughout the handbook, keep in mind that the National Labor Relations Board has in recent years taken a pretty hard look at some of employers' language, and the reason for that is their position has been some language may have a chilling effect on the ability of employees to engage in protected concerted activities. And those rights arise under Section 7 of the National Labor Relations Act and apply to all employees, even those in non-union settings. And so the board has focused on at-will statements that suggest to employees that nothing they could do or nothing can ever change the at-will relationship. So when you're crafting at-will statements, keep that in mind. Potentially include some language that nothing in the handbook's at-will description is meant to infringe upon Section 7 rights, or keep it flexible enough to avoid extra risk.
I think some of the language that I've seen that might trigger the board's focus is language like the at-will relationship can only be altered in writing by the president of the company, something like that. According to the board, that tells employees that, well, even if we unionize, there's no way that could change the at-will nature because the president would have to sign off on that. And of course, that's not true. If employees want to unionize, they can vote and unionize, and that has no bearing on whether the president of the company wants to agree to that or not. And so that's the type of language that the board has, in some instances, said might chill employees' belief that they can unionize. I think one of the other things that Jessie mentioned, which comes up a lot, is the relationship between acknowledgement pages and revisions to a handbook. So oftentimes you'll want to revise the handbook, like Jessie said, because of some change in the law or because your experience has told you that some change needs to happen. Well, when you have hired new employees, you've had the opportunity to give each of them, either in hard copy or direct them to your intranet, where the handbook can be found, and then collect from them actual written acknowledgement pages with their handwritten signature on them that you can stick in their personnel file. Well, when you're changing a handbook and you have hundreds or thousands of employees out there, it's often a difficult undertaking and one you probably don't even want to try, to have everyone sign a new acknowledgement page, because each time someone doesn't sign a page when you've asked for them might create more harm to you than having the people who signed the page actually return it to you. So oftentimes employers in that instance will simply send out an email, perhaps from an HR person, to all the employees, making sure that everyone has been directed to the website or the intranet where the handbook is available, pointing out the specific revisions that have been made. If you want to go the extra step and ask people to do an electronic sort of signature or checkbox that they have received the email and have acknowledged that it's their responsibility to go review and understand the handbook, that's something you can do, and that electronically those type of signatures might be easier to collect. That's something that employers have done. Another thing on the at-will or ability to modify the handbook, a lot of employers now, especially in response to some good case law that's come out from the Supreme Court about mandatory arbitration agreements, including those that waive class or collective action claims by employees. A lot of employers are putting those type of arbitration agreements or policies in their handbooks, but at the same time in those handbooks they are still saying that the handbook is at will and that the handbook language can be modified by the employer at any time for any reason. Those policies mandating arbitration and those policies that say that the handbook can be modified at any time can be in pretty direct conflict. There are some good cases. New York case law is particularly good for this, that say that an arbitration agreement that says that it can't be modified can trump the general language in the handbook saying that the handbook in general can be modified. But that's something to keep mindful if you are considering putting in some sort of mandatory arbitration provision in your handbook, making sure that it's binding on both the employer and employee and that it can't be modified, even though your handbook as a whole can be modified. Definitely some language that you want to pay attention to. For those of you from New York who are listening, the CLE code for New York is 692QGP. Our next topic is wage and hour disputes. Well, what's the goal of a handbook? It's to avoid those costly disputes that come up that are easily turned into from one disgruntled employee with an overtime claim into a huge collective action with huge damages, attorney's fees, possible liquidated damages, and penalties. As some of you who have had the unfortunate experience of facing these type of lawsuits understand, one employee's small wage dispute, if that employee can assert it as a collective claim, that small dispute can suddenly turn into something that is quite massive. And oftentimes your best solution is to try to settle the case quickly and still pay a lot of money and then change your policies to avoid future suits. What your handbook, though, wants to do, or your goal in your handbook, is to try to avoid those type of lawsuits being possible, or if someone is going to bring that sort of lawsuit, having statements in your handbook that suggest that employees knew that it was their burden to report all of their hours worked, and that if they didn't, that was their choice. So a couple things to keep in mind with respect to wage and hour law in your handbooks. One is non-exempt versus exempt employees. A lot of the wage and hour disputes tend to be misclassification cases where exempt employees argue that they were wrongly classified as exempt and that they instead of should have been classified as non-exempt and eligible for overtime compensation. Some mistakes that we often see in handbooks are employers thinking that anytime a salaried employee exists that they're exempt, and that those who might perform some exempt duties are automatically exempt, or that a job title is controlling, treating all managers as exempt, or not being specific as to what kind of rest and meal breaks are offered to employees. These things are details you want to be clear in your handbook. So for defining exempt and non-exempt employees, I think it's good in the handbook to list general categories of what types of employees would fall into each, and what are the benefits that are available and responsibilities to each type of employee, but to avoid listing in too much detail which positions fall into which category. That might just cause you problems in the future. Like we say, if you find that you need to change an exemption of a particular position, you don't want to have to revise all your handbooks to account for that revision. With respect to overtime, oftentimes employers make the mistake of saying, employee, you are not allowed to work overtime unless you are given prior authorization to work that. And if you do work overtime without prior authorization, we're not going to pay you. Well, under the wage and hour laws, if an employee is suffered or permitted to work by the employer, you owe that employee the wages that were worked. Instead, what we advise employers to do is to tell employees that they should get permission before working overtime, that if they do work overtime without permission, they're nevertheless going to be paid for that time, but then to treat that decision by the employee to work overtime without permission as a performance issue and address it under your normal performance review process, whether that's through a disciplinary structure or some sort of verbal or written warning. So I'll turn it to Jessie for the next goal.
Goal 5 is basically dealing with how do you communicate to employees in a handbook what's expected of them with respect to company-owned technological devices. And obviously, privacy concerns and all the changes that have happened during the advent of technology could easily be a standalone seminar that probably could be many days. So to the extent you have detailed privacy questions, Dorsey does have a really robust privacy practice led by Bob Rosenbaum, so feel free to forward those types of questions along. But for purposes of handbooks, the two issues we really want to flag here today are how to communicate to employees what their uses should be, and also how to address some privacy concerns from the employee aspect. So mistakes that we frequently see are failures to inform employees what the company expectations are with respect to its devices. And to avoid any confusion and to mitigate against the potential for disputes, we recommend that in handbooks, employers are very clear about the fact that the devices that the company distributes to its employees are company-owned. They're not personal devices, so while employees can use them for their work and their benefit, they're company-owned. We also recommend that the employers include language allowing the company to monitor what's being done on those devices in the event it needs to. So including language in the handbook to the effect that the company reserves the right to monitor its devices, including all content and information that may be stored, generated, received, sent, you name it. The company reserves the right to look into that and monitor that. Related to that is then again flagging for employees that because the devices are company-owned and because the company is reserving its right to monitor what's being done on their devices, employees should not have an expectation of privacy with respect to the information that they store or create on those devices. Once you lay those foundational principles out in the handbook, we also typically suggest that employers try to specify for employees, to the extent they can, what type of use is prohibited and what type of use is permitted. In this regard, one of the first steps to think about, even before drafting a handbook, is whether or not your company is going to allow employees to use company-owned devices for personal use, whether that be to check personal email, personal banking, uses like that that employees may or may not want to do at work on the devices, and what the employer's stance on that is going to be. So if the company decides to prohibit any type of personal use, spell that out in the handbook and try to enforce that as consistently as you can. If some type of personal use is going to be permitted, say that too and try to give employees some information on what types of use are permitted. So there's some sort of, again, baseline expectations that the employees know where the line is going to be drawn. At the same time, make sure you're prohibiting certain uses outright, and that should involve language prohibiting illegal conduct on company-owned devices, should prohibit any type of sending, creating, receiving any information or material that could be classified as obscene, discriminatory, defamatory, harassing in nature, so that you're limiting, to the extent you can, inappropriate information and content on your company devices and systems. And again, as we have discussed already, these provisions do have the implication to involve some Section 7 labor issues, particularly when you're including language in the handbook regarding what employees' duties are with respect to preserving and securing confidential or other sensitive company material. So Joel is going to discuss that overlap in the social media and sort of online web context, and can also link up how these issues interplay with the use of devices.
And like Jessie said, this privacy arena is becoming more and more important, and it's a huge issue for a lot of companies, and one that could take a lot more discussion by us. So I guess I'll reiterate Dorsey's privacy practice that Bob Catanaugh leads. I believe we have a seminar coming up in our Des Moines office regarding privacy issues. We also offer a fixed fee review of companies' cybersecurity policies and breach protocols, which would go well beyond the employment, employee-employer context of your privacy policies, something that you might want to consider. Jessie mentioned the next topic, or Goal 6, managing your social media and how that might touch upon National Labor Relations Board issues. As some of you may have been aware, the board has been taking a very interested look at social media policies by employers and determining whether, in the board's view, those policies infringe upon employees' rights to discuss the terms and conditions of their employment. As Jessie mentioned, this labor law applies not just to unionized employment workforces, but also to those that are not unionized. So even if you don't have a union currently, you still need to pay attention to these rules. What can happen in a non-unionized workplace is if you have a policy that is running afoul of what the board believes is permissible, and let's say you terminate an employee for having violated your social media policy, that employee can still file a charge with the board, and the board can then come after you for violating labor law, even if the employee is not a member of a union. So the board has been pretty helpful in the last couple of years of providing guidance on what kind of policies employers may put in place regarding social media. Back several years ago, there was the first kind of case that the board brought and settled, the Facebook case. And just to remind you of those facts, that was where an employee was fired after posting some negative comments on Facebook about her supervisor. And after her supervisor denied her request to have union representation in connection with her firing. She went on Facebook and called him some names that I won't mention in this webinar, but including calling him a scumbag, which spurred some supportive comments by her coworkers on Facebook. Now, the board considered this to be an exercise of the employee's Section 7 rights because she was discussing the terms and conditions of her employment, namely her supervisor's poor treatment of her and her supervisor's denial of her union representation request. And the board also considered to be concerted activity, or activity that was taken in concert with others because her coworkers posted comments or liked her comments on Facebook. In that case, the employer ended up settling the case, but it started to spur more action by the board. The board issued a couple memoranda discussing what kind of social media policies were and were not okay by employers. Ultimately, the board issued a memorandum that actually put in place a model policy that employers could look to see whether their policies passed the board's muster. What we have done in recent years after that model policy that the board published came out is actually advise employers really to follow that model as closely as you can. It's not a bad model. It talks in rather vague terms that I think are nonetheless helpful, but you'll be assured that the board is not going to take issue with your policy if you're following the model that they have themselves published. What you want to do with or without that model policy is avoid general prohibitions on employees fraternizing. You want to avoid them being able to discuss their wages or hours or terms and conditions of employment. You want to prohibit just their general social media activity. What you're trying to do is avoid chilling employees' rights to discuss their employment online or otherwise. In Minnesota, these type of policies overlap a lot with the recent act that was passed this summer, the Women's Economic Security Act. Despite its name, that statute, which we're already referring to as WESA, it applies both to men and women, and it gives employees the right to discuss their wages and prohibits employers from taking any adverse action against them when they do discuss those wages. Obviously, that right to discuss wages overlaps almost completely with the rights that employees have under the National Labor Relations Act, but it allows them, employees now, a new avenue to assert their rights. Under that statute, though, there's now an affirmative obligation by employers to put in their handbooks, and this would be employers of a certain size. I think the number is 21 employees or more, but obviously that's going to apply to most employers that are listening to this webinar and otherwise. But to include in their handbooks specific language telling employees that they do have that right to discuss their wages. One other thing with respect to social media and the board that you might consider including in your handbook is a specific statement that the policies don't affect employees' rights under the National Labor Relations Act. The board hasn't come out specifically supporting that type of statement, but hasn't necessarily said that it is useless. So in the end, it might not be all that helpful to say to employees, regardless of what else is in this handbook, you still have your Section 7 rights. I don't think it harms you to include that type of statement somewhere in the handbook. Jessie was mentioning with respect to privacy that for social media you also want to keep in mind what kind of confidentiality rules you can put in place. The model policy that the board has put out, along with some of its discussions of other policies that it is viewed to be compliant and not compliant with Section 7, really get to tying your confidentiality rules to the specific business information that you want kept confidential. So for example, I think there's a case that the board looked at where it was a healthcare employer, and when its confidentiality policies were specific to not permitting employees to disclose confidential patient or other types of information, that was found to be perfectly okay, while other employers that just generally prohibited employees from discussing confidential information online those type of policies are not okay because that type of confidential information could include wages or terms of conditions of their employment or their coworkers. Turn it to Jessie now for the next goal.
The next goal is maintaining a flexible dress code. Dress code policies are really a common, often almost always pop up in handbooks, and they're frequently in place in all sorts of different companies for a variety of reasons. And at first blush, these policies seem pretty benign, but what employers need to keep in mind is that they do have the potential to implicate Title VII rights that employees have, as well as rights under various state and local laws. Title VII is the federal statute that, among other things, protects employees and job applicants and their sincerely held religious beliefs. And where job applicants and employees hold those sincere religious beliefs, employers are required to provide accommodations that accommodate those religious beliefs unless doing so would pose an undue hardship to the company. Religious rights in the Title VII context have, over the past few years, become an item of EEOC interest. There have been several litigated cases involving the EEOC, particularly in the retail and services industries, that challenge employers' failures to provide accommodations from their dress code policies to accommodate sincerely held religious beliefs. And some of those cases have met with success. There have been a few favorable rulings on various motions, and there have also been some pretty high settlement amounts in those litigated contexts. Earlier this year, the EEOC also issued 2 written resources on religious rights, one of which was a fact sheet and the other was a question and answer resource, both of which spoke to religious garb and grooming in the workplace. Both of the resources discussed employer obligations in the Title VII context, and then the question and answer resource walked through a number of hypothetical situations in which the EEOC provided its analysis on what the employer should or could have done and what the legal implications of the various actions were. So when taken together, these recent cases and then the March 2014 resources suggest that the EEOC is quite skeptical of broadly applicable unflexible dress code policies, and that does have the potential to play into how employers are drafting their dress code policies in a handbook. So a few things to keep in mind as you're drafting the handbook. First of all, if you have a dress code and it's important to your business and you're going to enforce it, know the rationale ahead of time, and keep in mind that the EEOC is not going to consider certain defenses legitimate if and when an employee or a job applicant challenges an employer's failure to provide them an accommodation. Specifically in the March resources, the EEOC said that customer preferences or customer biases will never constitute a defense, and even goals like marketing, sort of client-driven and or safety concerns might provide a defense in failure to accommodate situations, but not always. So be aware of that and know your rationale ahead of time. And what the EEOC is really focusing in on, as sort of an aside off the handbook topic, is when folks need accommodations, they want employers to be engaging in a case-by-case interactive process with the employee to identify what the needs are and then identify a reasonable accommodation. This doesn't mean when employees or job applicants approach you with needs that the employer needs to accept outright their first preference. But it does mean that the employer is going to need to work with those people and figure out what is reasonable and not rely solely on their rationale as a means to deny outright requests. So when drafting a handbook, what can you do to allow yourself the ability to maintain your dress code, but also make sure that employees are aware that there is flexibility and that they do have rights to request these accommodations? First, we often advise folks to include in the handbook language some statements clarifying that while the company maintains a dress code, nothing in the policy limits the employee's ability to wear cultural or religious garb or clothing. We also typically suggest in any provisions relating to accommodations, including perhaps ADA provisions or provisions addressing disability accommodations, to include language that encourages employees to report their needs and be encouraged to come forward to specific point people in order to request an accommodation where they need it.
Thanks, Jessie. Now on to Goal 8, clarifying your available leave. Here's where your handbook wants to tell employees what kind of leave is available to them, not tie you necessarily to having to provide leave in all cases or in specific cases, but telling employees what's available, how to ask for more information about what kind of leave they can have, and making the descriptions more general, as we've been talking about before. So the types of leave that you might consider or be required to include in your handbook, we'll start with the Family and Medical Leave Act. Under that act, you actually required in your handbook to notify employees of their statutory rights. And now with more and more FMLA revisions and guidance being put out by the government, oftentimes I'm seeing FMLA policies that are rather robust and lengthy in handbooks, and that's almost necessary now with all the various ways that FMLA can apply to people, whether it's through the normal, serious health condition of the employee, him or herself, but also now you have same-sex marriage issues, you have military employee issues. There's a lot of things and details that you probably need to include now in your FMLA policy that must be in the handbook. In addition to that federal leave statute, the FMLA, in each state there's going to be a whole range of different types of leave that are available to employees. We've mentioned a couple here, Minnesota having the new pregnancy and parenting leave policy that was part of the Women's Economic Security Act that was passed this summer. But of course in each state, you out there in various states know you've got a whole different set of state law leaves that employees are eligible for, whether that's jury leave or bereavement leave or the sick leave that's applicable in your state. And with respect to sick leave, keeping in mind that different states have different rules that can vary dramatically, whether it's a state that totally prohibits a use it or lose it type sick or vacation leave policy like California, or other states that don't say anything about that, or states like Minnesota where it's really the policy that dictates whether use it or lose it is allowed, treated more of kind of a contract language analysis. The question here comes up for employers, well, when I have employees in multiple states, do I really need to include in my single handbook all the various state leaves that are available under all these different state laws? Do I need to have addendums for each state that apply to those state employees that list out all their leaves? There's a couple of avenues you can take when you've got employees in different states. If it's a lot of states, one thing we typically advise employers to do is simply to say in the handbook, include the state leave laws that maybe for the most of your employees or where your headquarters are at, but otherwise just state in the handbook for questions regarding specific state leave laws that you may be eligible for, please see your HR representative in your local office, and then prepare your HR people to be able to provide information about the leave that's available in each state. That way you don't have to provide a bunch of information that is irrelevant and useless for a lot of employees, but still tell them that they are eligible to take certain leave and tell them where they can get more information about how to take it. So a couple of mistakes that we often see with respect to leave is failing to provide those mandatory notices, particularly in the FMLA, but there are certain state laws that also require that employers include notice in handbooks that certain leaves are available. Failing to include those mandatory types of leave in the policies, and then not describing the amount or method of accrual of types of leave. And so employees should be told very specifically about how their vacation or sick leave is accrued throughout the time of their employment, whether there's a probationary period, whether there's a cap on leave. That type of information is something that employees should really be told, so you are not having to field constant questions as employees are looking at their pay stubs and wondering why they have a certain amount of vacation leave available to them at a certain point or not.
Before we dive into the next goal, which is harassment and discrimination policies, I'll again say for the New York folks, the New York CLE code is 692QGP. So how do you effectively funnel your complaints in the harassment and discrimination context, and why does it matter? First, I think we'll walk through what we typically suggest in terms of a structure in this context, and then we'll walk through some of the rationale behind those specific parts of those provisions. So a few mistakes that we frequently see are failing to incorporate standalone policies, and what we mean by that is there are really some strong reasons to have a robust harassment and discrimination policy. So sticking that language in other policies that discuss conduct in the workplace or generic things like that isn't appropriate. This is the section that you do want to have a standalone policy, and you do want to include some detail for reasons that we'll discuss later. So first, we typically recommend that you begin by defining what harassment and discrimination means. So provide employees with a basic definition and a non-exclusive but comprehensive list of examples of what type of conduct is going to fall under each of those terms. And the reason we do that is we want to make sure employees have a sense of what type of conduct is prohibited and what that conduct can look like, because not all sexual harassment is going to look the same, nor is all discrimination. And as a general pointer, whenever we provide lists or list out protected classes and handbook policies, we generally recommend that you use language that indicates that the list is non-exclusive. So include language including but not limited to, if you're discussing protected classes, add a tagline at the end of your list saying in any other protected class under applicable law to maintain flexibility in the event the law changes, which, as we have seen and Joel has discussed in the context of WISA in Minnesota, we now in Minnesota have a new protected class for familial status as of this May.
I think another good reason also to include that type of list in that definition is oftentimes your other policies may need to refer to that list. For example, your social media policy may want to prohibit behavior online, which would be treated as impermissible behavior in the workplace. And so being able to reference that robust definition of what types of categories are protected is useful to tell employees what also is impermissible for their online activities.
So once you identify what the conduct is and provide employees with what types of activities are going to give rise to those prohibited conduct, the next step we advise employers to take is to lay out a pretty detailed complaint procedure. So the first thing you're going to want to do is identify a point person as well as some backup people to whom employees can go to raise concerns or complaints under this policy. The reason we suggest including more than one person is because you want to make sure that employees have someone they can go to that they feel comfortable with, not only because you want to encourage employees to bring forth concerns, but also because you want to make sure that in the event one of the identified point people is involved in the conduct or the alleged misconduct, that employee isn't forced by the policy to complain about that person to that person. Once you lay out how employees should be making reports and to whom they should be making them, next indicate what the company is going to do upon receipt of those complaints. And that's really to reiterate to employees that the company takes the conduct seriously, that the company is going to initiate prompt action, which may include an investigation, that the company will then take appropriate action based on its investigation or other means of vetting this conduct. And finally, reiterating that in no way will the company retaliate against persons who are making reports under this policy is something that's really important to include in this step.
So now we'll move to our final goal, covering your bases. What's this final thing that you want to do in your handbook? You want to make sure that you've covered everything you need to cover. So that might include covering different state laws to the extent you need to cover them, as we've been discussing before. Another is knowing what specific policies that you must include in the handbook and those that you should not put in the handbook at all. So some examples of policies that should not be provided in your handbook might be those under the Federal Fair Credit Reporting Act, the Minnesota version of that, which is Section 13C.02, and there might be other state statutes in other states that are similar to that. And then your drug and alcohol testing policy, at least under Minnesota law. So under the Fair Credit Reporting Act, or FCRA, that puts on employers several obligations in connection with obtaining background checks for employees or prospective employees, and different types of notice that must be required to be provided to employees both before the check is done and then if adverse action is taken in connection with a background check. So in this slide you can see lots of different notice requirements, providing copies of reports to employees, and different notices to employees even after adverse employment action is taken. All of this stuff under FCRA, under the statute, should be provided in a separate standalone policy. Another thing to keep in mind with FCRA is that oftentimes employers will ask for or put in their FCRA disclosure policies a release by employees that says if there's some wrong information in the background check report that we receive and that we act upon, you employee agree to release us from any liability in connection with that. There's been some recent case law, and actually some plaintiffs' lawyers have taken up these cases more and more in recent years, that a release included in the same policy that provides employees notice of their FCRA rights is not valid. It makes both the release invalid and the FCRA notice itself potentially invalid. So if you have a release in your FCRA notice, or if you're considering one, keep that in mind. Similar to the federal version, there's the Minnesota version, and as I said, probably many states out there have baby FCRA laws that similarly require that notices and provisions of your background check policy be provided in a standalone document. And I know that employers generally do this right. In your packet of new employee information, you'll often have a separate set of policies or stack of documents that are provided to employees that list out their background check rights and obligations and have them sign off. But you just want to make sure and keep that separate, not have that be pulled into your general handbook policies. The other policy I talked about that should be a standalone and not necessarily included in the handbook itself are those pertaining to drug and alcohol testing. On a related note to this, oftentimes we have advised employers who have operations in Minnesota and elsewhere on what kind of alcohol and drug testing policy that they should have. Minnesota has probably among the most stringent and employee-friendly laws out there regarding alcohol and drug testing. So we have often found that multi-state employers with operations in Minnesota typically are okay in following a Minnesota compliant policy. This, among other issues that we talked about, brings up California law. And I see that one of the questions that's come in as we've been talking here is a question related to our discussion of different state operations and whether you can include in one handbook different state rules specific to California. You know, oftentimes we recommend to multi-state employers that do have operations in California that it might be a good idea to have an entire separate handbook for your California employees So many of the policies and the laws in California are so different and so much more employee-friendly than in other states that it might be a good idea to have a California-specific policy. Just one thing to keep that comes to mind would be rest and meal breaks, for example. Those breaks are provided to California employees much more than in other states and require a lot more detail about when, for example, rest breaks must be given to employees throughout the course of an 8-hour day or a 10-hour or a 12-hour day. That, among many other policies, might counsel in favor of a California-specific handbook. That also tends to apply to Montana operations with Montana-specific probationary period. We have found that it's often best to have a separate Montana employee handbook, even if your handbook otherwise covers multiple states, just because Montana's at-will employment law is so specific. So some general conclusions before we take up a couple other questions that have come in to us throughout the hour is you want to review your handbook at least annually. We've been discussing today several legal changes that have occurred just in Minnesota that not only counsel in favor of, but actually require changes in your handbook. The Minnesota Women's Economic Security Act is the law that made some of those changes. There are probably similar laws in other states that have either required or suggested that you make those changes. So it's a good idea to do a robust review of your handbook on at least an annual basis to make sure you are keeping up to date and compliant with state law. Another frequent change in the law recently has been FMLA updates by the Department of Labor. There have been several changes in the FMLA regulations that, like I said, have really changed the obligations of employers of what kind of FMLA leave you should offer to employees. So while your FMLA policy might be lengthy and descriptive in your handbook, because of some recent changes, it might not be fully compliant with what the law requires.
Addressing one of the questions that's come in about sexual harassment and discrimination policies, and the question is, are there any risks to encouraging and actually mandating internal complaints versus using more flexible language? Oftentimes, we will see employers and have used language suggesting that when you identify point people, that employees should be raising complaints under the policy too. There's often some language included that suggests that reports to anyone other than these people is insufficient to make a report under this policy. The reason behind that language is so that the company is getting the information that it needs to avoid vicarious liability, to avoid arguments that it should have known about the harassment but didn't. That's why we like to identify point people. At the same time, there is potentially some risk in using that type of language based on some of the EEOC's recent activities. Specifically, they have recently scrutinized, particularly in the release agreement context, language that suggests or chills employees from reporting concerns to outside agencies. So to the extent that there's language identifying point people and indicating that a report other than to those people is ineffective, there's a potential risk in that corollary from the EEOC's standpoint. But on the other hand, there are really strong reasons we suggest often maintaining language similar to that, maybe a little bit more flexible, but similar to that language, because under 2 Minnesota Supreme Court decisions that came down in 1998, there's an affirmative defense available to employers in some situations involving sexual harassment. And under that affirmative defense, when a supervisor engages in sexual harassment but no adverse employment action was taken in the sense that the employee wasn't fired or terminated or demoted or changed into a lesser job role, an employer can avoid becoming vicariously liable for the supervisor's conduct if it can show 2 things. The first of which if it can show it exercised reasonable care to prevent and promptly correct any sexual harassment, and 2, that the employee unreasonably failed to take advantage of preventative opportunities provided by the employer. So maintaining a robust sexual harassment, general harassment, discrimination policy speaks to both of those prongs because it shows to employees and outsiders that the company prohibits the activity, that the employer provides employees with a process to raise concerns and encourages employees to raise concerns, and that it's also going to initiate prompt action when in fact those concerns are reported. Under the second prong, obviously if an employee fails to avail himself or herself of that process or makes a report to a colleague as opposed to one of the point people, there's some arguments that can be made by the employer that, hey, this employee didn't follow the process that was outlined to them in the handbook that they read and signed an acknowledgement form saying they understood.
Thanks, Jessie, and thank you all for listening. We hope that you gained some benefit from this hour. Dorsey, as we said, does offer employment advice in every state in the country. We offer both handbook review on an hourly basis or on a flat rate basis. So if you do have a handbook that you're needing to be reviewed or to be created in the first instance, feel free to contact us and we will be happy to assist. Thank you.